Good morning, counsel.
Good morning, Your Honors, and may it please the Court. My name is Robert Garner. I am here on behalf of PCG Trading LLC, the plaintiff appellant, and I wish to thank the Court for allowing me to appear pro hoc vice. With me at counsel table is Mr. Walco, our Massachusetts counsel. The underlying case here is a legal malpractice action by PCG against Seyfarth Shaw and four of its attorneys for what PCG alleges is negligence and conflicted representation that resulted in an adverse liability sorry, Your Honors, a successor liability judgment against PCG Trading. The action was filed in 2009. Shortly thereafter, PCG moved to admit me pro hoc vice. Around the same time, two articles came out, one in the National Law Journal, quoting an attorney in my law firm, William Brewer, and another in the ABA Law Journal, which contained no comment from Mr. Brewer. And the defendants took issue and opposed pro hoc vice admission, and the Court denied for essentially the reasons cited by the defendants in their argument.
Mr. Garner, if I could ask you a question, I'm sort of starting at the end, but why don't you think that Rule 3.6D has more of a bearing on here than I took from your brief, which is the provision about no lawyer associated in a firm with a lawyer subject to paragraph A, which is about, not speaking in ways that one shouldn't speak, may make a statement prohibited by paragraph A. So if you've got Mr. Brewer and, you're subject to A, you don't disagree with that, right?
Correct, Your Honor. Although we do disagree that A was violated.
Yeah, no, I understand that, but you're subject to it.
Correct, Your Honor.
So if one assumes that, just assume for the minute that somebody could say he did, wouldn't that be a basis to not let you appear pro hoc vice?
No, Your Honor. What Rule 3.6 imputes is an obligation to obey the rules. So what it prevents is one attorney from being admitted within the jurisdiction and other attorneys who are not within the jurisdiction from being free to not comply with the rules of the jurisdiction. So what 3.6 does says that if I were admitted pro hoc vice, all the employees and members of the firm would have an individual obligation to comply with the Massachusetts Rules of Professional Conduct. What it does not say is that their conduct should be imputed to the attorney who is admitted. Attorneys would still be, under 3.6D, are still responsible for their own individual conduct.
But if you're a Superior Court judge with a fair amount of discretion over these matters, couldn't you look at that? I mean, if you thought that, and I'm not trying to argue whether Mr. Brewer did or didn't, but let's just assume that somebody did. You could just posit another case. Somebody really unquestionably violated would fit with the conduct would fit within 3.6A, but it's by a lawyer, not the one who's seeking pro hoc vice, but a member of the firm. Would that not be a reason for the Superior Court judge to say, I know you didn't say that, but I'm not going to allow you to appear?
We don't believe so, Your Honor. Let me go backtrack, and that is that the rules covering pro hoc vice admission, base pro hoc vice admission on an attorney's individual conduct. It would be arbitrary and unreasonable to hold an attorney accountable on his own admission for the statements of another attorney, and the implications for that are broad because it wouldn't just apply to pro hoc vice admission. It would set a standard in the Commonwealth that any attorney could be disciplined or reprimanded for the conduct of another attorney. There's nothing here that says that Rule 3.6D, as applied as suggested by the defendants here, would be limited to pro hoc vice admission. It would be all disciplinary actions.
No. I'm just saying as a basis, a legitimate basis for a judge to say, I'm sorry, Mr. New York lawyer, but, given what members of your firm have done, and again, I'm not talking about you or your firm, but just hypothetically, what members of your firm have done, I don't think it is appropriate to allow you to represent this client in this Massachusetts case.
Your Honor, that's not what the rule says. It's strictly, it is an obligation. If this court obviously wishes to make that interpretation, it can, but that's not where the rule is, and that is not the implication of the pro hoc vice admission standard in this court. It is the standard that the defendants have advocated. Let me add one thing to that. It would actually be more appropriate for the court to grant admission, therefore imputing the obligation to the other members of the firm, bringing them within the court's jurisdiction, and thereby subject to discipline. And that would be the better way of controlling, certainly of controlling the conduct of other members of the firm.
Sorry.
Oh, please
I
go
was
ahead,
just
Your
going to ask a question about whether you think that other rules have some, by analogy, could be considered appropriate here. Other rules which suggest that a lawyer might be responsible for, if they're direct supervisory authority over another lawyer, or in the circumstances where they have knowledge of the conduct or ratify the conduct. Do you think those have any implication here, or are they just limited to circumstances within the jurisdiction?
No, Your Honor. I thank you for reminding me of that. Rule 5.1 actually addresses what Your Honor has asked me, and that is Rule 5.1 does set the standard of imputation of conduct within the Commonwealth, and it is very clear that conduct should be imputed upward. What is being advocated here is a reverse imputation standard, which is what I indirectly addressed, that this is not the standard under which attorneys in the Commonwealth are held. And that is that the standard is that an attorney who has some control over the conduct of the supposedly malacting attorney should have some imputation of that conduct to him or her, but certainly not an attorney who is not in control. Otherwise, we do set up, as I mentioned before to Your Honor, that we set up the standard by which attorneys in Massachusetts are going to be held accountable for the conduct of any other attorney in a law firm, and that would extend beyond pro hoc vice admission or anything to control the courtroom.
But isn't there a concern? Let's take an example that is plainly not this case, all right? Let's imagine you had a law firm in New York which was under investigation for conspiring to generate false workers' compensation claims or fraudulent automobile insurance claims. And the view was that they were running this group which was doing bogus claims, and the senior partner of that particular firm was under investigation for it. And the question comes, can an associate of that firm now apply pro hoc vice to a court in Massachusetts? Is it your view that the court in Massachusetts cannot say, I have serious concerns about how this firm is being run because of its senior partner's conduct, which is under investigation, and I don't think I want this associate from this firm to be appearing here? I mean, by your view, the judge could not do that, I gather.
Your Honor, I think the judge might be able to do it, but probably not through the vehicle of pro hoc vice admission. If the judge wants to make findings of fact and disqualify a law firm, she is perfectly able to do so. But to deny an individual attorney pro hoc vice admission and all the implications that has not only for the client but for the attorney himself in his personal career, to be holding him accountable for the actions of others, is different. If you want to disqualify a firm, then you hold the firm accountable for the disqualification based on the actions of the firm. But that's not what was done here. And there is, of course, in this case, there is no indication, of course, that the firm did anything untoward at all. So that does not arise in this case. And I think this also has to be looked at as well, Your Honor, in the context of this case, to isolate the imputation argument from what happened here in terms of a pro hoc vice admission, I think would be incorrect.
Okay, well, let's go to that. I gather that the only claim of misconduct here relates to what Mr. Brewer said in response to a telephone call from a reporter from the National Law Review.
That is correct, Your Honor.
And is there any dispute that the quote in the National Law Journal is accurate?
It has not been disputed in the record, but if you look at the quote itself in the National Law Journal, which is in the appendix, you'll see that it contains brackets and replacements, so we don't know what the actual quote was without have seen what the reporter's notes were.
But And your argument, I gather, is that he was simply paraphrasing the complaint.
I think the quote is essentially accurate, and it goes to a central allegation of the complaint in that Seyfarth Shaw and its attorneys made conflicting representations to different courts depending on which client they were representing, and it accrued to the detriment of our client. And that was the only statement he made. He never, Mr. Brewer did not accuse Seyfarth Shaw or any of its attorneys of having a propensity for untruthfulness or of having bad character at all that would fall within any of the prescriptions in the commentary to Rule 3.6. He merely said that they misstated the facts. If you look at the record, you will see that in their motion to the Essex Superior Court, and if you want, I can provide Your Honor with the record cites. The motion to the Essex Superior Court is at 137 to 138 in the record.
I mean, but that matters less than what your complaint says in this court. As I gather, I gather you're claiming it's a paraphrase of the allegations in this case, is it not?
No, our complaint is essentially one of the central allegations of our complaint are these conflicting
It's based on the
representations.
conduct in Essex Court.
On the Essex Court and then later in the Norfolk Superior Court, that these conflicting representations were picked up by Judge Brady in the Norfolk Superior Court and used as evidence against my client.
I'm aware of that, but do we need to look any further than the complaint in this case in order to, in your view, find justification for his remarks as paraphrasing the gist of the allegations?
Yes, Your Honor. I think you need to look at the complaint and the post-trial proposed findings of fact that were filed with the Norfolk Superior Court. They are referenced in the complaint, not in detail, but there is an allegation in the complaint that Seyfarth and its attorneys pursued a defense in the Norfolk Superior Court that they knew to be false, and that's based on the statements they had made in the Essex Superior Court.
Mr. Garner, what do they do in other jurisdictions when they're confronted with situations like this?
I have not researched that, Your Honor. I do know of a couple of cases in New York where, actually I know of one case in Texas where there was a disqualification of a law firm, but there the analysis was completely different. It was the law firm itself. There was no imputation of conduct to any single attorney. It was just a blanket prohibition.
I take it it's your position that unless there was a violation of Rule 3.6, then this denial of the motion for Pro Hoc Vice admission was arbitrary and capricious?
That is correct, Your Honor. Actually, our position is that it is arbitrary and capricious unless there is a violation, and even if there was a violation, it is arbitrary and capricious to hold a subordinate attorney accountable for the conduct of a superior when the court certainly has other remedies available that are less drastic and less harmful to both the client and the individual attorney who was denied.
But just to take that, though, if you had, let's assume that you have a case and somebody is actually I'm just trying to understand the consequence of your argument. Somebody like you is admitted here in Massachusetts. Meanwhile, back in New York, a partner of yours is going on the airwaves and saying stuff that isn't the gist of the complaint, but is way outside the complaint and, just accept very prejudicial to the interests of Seyfarth Shaw. Do you say that the Massachusetts judge has to say she could not tell you that you could no longer serve Pro Hoc Vice because of what your partner back in New York is doing? Talking about this lawsuit.
Your Honor, the remedy would be...
she doesn't have jurisdiction over him.
Yes, she would, under Rule 3.6d. She would have jurisdiction over him. That's exactly what Rule 3.6d grants, is if it imputes the obligation to obey the rules
Okay, all right.
to the others.
But assume she does. You're right. But couldn't she say, just as an immediate remedy right here, out, go?
Your Honor, that's not what the courts in Massachusetts have done. As a matter of fact, taking a moment to get to it, but there's one case, I think it's the Merle case, that we have cited that both the defendants and PCG has cited in its briefing, in which the court does distinguish between the conduct of various lawyers. In this case, the court distinguished between. May I finish?
Of course.
The court distinguished between the conduct of the attorney who was seeking pro hoc vice admission and other attorneys from his firm who are already admitted in Massachusetts, and therefore allowed them to continue appearing, but held that the one attorney who had made the comments, and the conduct, of course, was much more egregious in all the cases than what is alleged here. The attorney who made the statement would be precluded while the others would remain in the case, and that's how the court handled the discipline, and that is consistent with Rule 3.6d.
Mr. Garner, your time is up.
I thank you, Your Honor, and we refer to our briefs for the rest of our argument, and thank you for letting me appear.
Mr. Chief Justice and members of the court, may it please the court, my name is Robert Muldoon. I appear for the defendants. With me is David Deneen. It's his first appearance in this court. I have three very basic points to make, but I'm going to start what is, I think, the most important one, and it stems from the first questions that were asked by Your Honors of Mr. Garner. William Brewer is the boss in this case. He has been identified from the filing of the first unamended complaint to the left of Mr. Walco's and his firm's name, Mr. Brewer and Mr. Garner, employer and subordinate, senior and junior, as, quote, of counsel, unadmitted at the time, subsequent to the filing of the lawsuit in the latter part of 2009. There was a request made by Mr. Walco for the admission of two members of that firm, Mr. Brewer and Mr. Walco. And Your Honor's question as to...
And Mr.
Mr.
Garner.
Garner.
Mr. Garner. Your Honor's question as to the facts that the judge, Judge Hinkle, could have had in mind, of course, are tied in many respects to the calendar. We're not sort of dogs in the manger trying to keep outside lawyers from coming in. Early in October, we were asked if we would assent to the motions to admit pro hac vice both Mr. Brewer and Mr. Garner. And we assented, knowing nothing ill of them, and we assented to that. The month of October went by and the motions weren't filed. On October 29th, they asked, or they informed us that, in fact, they were going forward only with Mr. Garner and not with Mr. Brewer. Would we assent or oppose that motion? And I informed Massachusetts Council we would not oppose that motion. Very shortly after, that was on October 29th, and as the record shows, on that day, later in the day, it was learned that Mr. Brewer had given this statement to the National Law Journal. It appeared on the National Law Journal website that day. Having been informed of that, we informed Mr. Walco that we would withdraw the assent to Mr. Garner pending an action by the court on this, and that we would file an objection, so informed the court, and we did. We opposed it.
Your reference to timing seems to suggest a complicity, but you don't actually in your motion refer to that particular rule. In fact, your motion, if I'm correct, I may not have everything, seems solely to focus on 3.6a. Is that right?
3.6a and 3.6d and its interaction.
And in fact, the judge, am I correct, really adopted, didn't really discuss it, adopted those pages in your memorandum.
She did, including pages 2 through 5, which include the facts that I'm talking about now. That is to say, the fact of asking us to assent to Mr. Garner without Mr. Brewer, and we gave that assent, then found what Mr. Brewer had done apparently on that day or the day before. 2 days before, I beg your pardon.
It doesn't make a reference to, and thus I assume it's not within the contemplation of the motion judge, to B, 3.6b1, whether the claim or offense or defense involved was stated in, that is, when Mr. Brewer made the statement that was reported in the National Law Journal, that actually was the claim that was involved in the case. When you read the National Law Journal, it talks about claims.
Yes,
And
ma'am.
then it has a 1 or 2 line statement, and then it continues to discuss the claims in the underlying action.
That's correct.
Okay. So you weren't focusing on that, and the judge didn't have before her that, but that would be, would it not, a defense? This is actually just a statement of the claim.
Part of it is clearly a statement of the claim, and part of it does state what the case is about. What is not anywhere in the case are the claims in those sentences that are attributed to that Mr. Brewer spoke, about filing papers to relieve responsibility to another client, misstating facts, that is to say lying to judges, lying to courts. All of that was
That's
in the
not part of the
context.
claim?
That is part of the claim.
Right.
It's not part of their claim, it's part of our claim. It's not part of the complaint.
It's
And
not?
you can look through the complaint and the amended complaint
Okay.
to find words, I think, and I suspect
Well-
that's what Judge Hinkle did, that finds out whether or not those things are supported by a description of the complaint, which would be permitted.
Could I understand
Yes.
better the underlying complaint then, the one we're talking about having been
Yes.
filed, in which this may or may not refer to? As I understand it, there were 2 clients,
That's correct.
and one of them was Converge, and at that point, Seyfarth represented both Converge and PCG.
Yes,
And PCG went to Essex Court
yes.
and essentially made a statement that Converge was assetless.
In Massachusetts.
Right.
Those are the 2 words that are key in that submission.
They were
and that
assetless
was
in-
true. That was true. That's a true statement. And it's adopted as a true statement by PCG in subsequent events when Mr. Brewer's firm took over the trial of the case.
So there's no difference between saying this is a defunct firm, which later had implications in another case for holding them to be liable, right? So there was no distinction then to be made in this complaint that they may not have had a sufficient assets as compared to saying they were assetless? Sufficient assets to pay a wage judgment?
There is a distinction because, in fact, as it has turned out, there have been and there are substantial assets of Converge which have been applied to for indemnification against the claim against the defendants in this case. So the careful... I beg your pardon.
Just trying to understand.
Right.
But didn't this draw attention to the PCG as a potential source of paying the liabilities? I mean, isn't that the point of this, whether it's accurate or not? I mean, just saying what they're trying to say here in this complaint.
What they're trying to say is to have sound bites that get on the Internet that characterize the defendants in this law firm as a law firm which, in a case, did things. They talk about the
Right.
motivation of the firm and the defendants. Their motivation was to relieve itself of responsibility to another client of theirs. Number one, there is nothing in their complaint that suggests that that was the intention on the part of the law firm in respect to concluding the Essex County matter and filing that document. Secondly, they say that the firm not only misstated the facts, but stated the facts in a way that supported their notion of PCG's successor liability claim. That also goes to the question of the intent of the lawyers and the law firm in what they did.
Yeah, but paragraph 23 on page 77 of the appendix says that that the Seyfarth source sought to withdraw in the Essex
In the Essex
action.
case, that is correct.
So, I mean, he says they attempted to relieve themselves of responsibility. He didn't use the term move to withdraw, but when you move to withdraw, don't you relieve yourself from responsibility from the case?
If Your Honor, please, the concern of the complaint against the law firm is that motion wasn't sealed. Not that the language was false, but that the lawyer did not have it sealed. That is what the complaint states as the basic flaw, or the claim, they say, against the firm from which their damages flow was as the result of their not sealing that or having the court seal that
But
complaint.
then there's also the concern that what Seyfarth wrote was then used by the judge in Norfolk as a basis for finding that the asset purchase was a de facto merger.
Also not correct. That formed no
Well,
part.
It may not be correct.
Right.
You may not view it to be correct, but
Right.
it appears to be what the complaint essentially alleges is that they made allegations in order to withdraw from the case in Essex that came back to bite the client in Norfolk. That's the gist of the action, isn't it?
They attribute that to a motive in this communication with National Law Journal, that there is a motive there to serve the self-interest of Seyfarth Shaw, not to serve anybody else's interest, but to serve Seyfarth Shaw's own self-interest in filing that Essex case.
But are we going to then, I mean, a reporter calls up an attorney because you've just filed a case worthy of public interest and says, I gather I'm about to write an article about this case that you filed. Do you want to discuss the claims? And you attempt to give a soundbite which sets forth what you think to be the gist of the allegations, and there are words used, and maybe it's a little bit different from the precise language of the complaint. Are we going to say that that's a violation of 3.6a?
Can be, depending on the content of the words. There's a pretty good old rule that goes back long before the adoption of the model rules here, and that is that something that's before the court, the best thing is to say nothing.
But
if you
But we no longer abide by that
We
rule.
changed the rule.
We've changed the rule, and you can have a limited communication with respect to the content of what the claims are and the claims are made. It does not permit you, as you know from the comments under the rule, to use a communication of that sort to attack the character, the credibility, or the reputation of a party in a lawsuit. And what those words do, they may be few or they may be many, what
But
those
the
words
lawsuit,
do all of
the
that.
lawsuit attacks the character, the reputation, and the credibility of the law firm. I mean, that's what the lawsuit is about.
The lawsuit is about alleged claims that there was malpractice in the trial of a case in Norfolk County that had serious problems because of things that happened in another case in Essex County. There's nothing in the lawsuit that states that they are not trustworthy or that they acted to serve their own self-interest at the expense of either of these clients. It's designed to, in a sense, poison the well as to the nature of the lawyers who were involved in the representation of these clients.
Let's discuss the poison the well. I mean, those of us who sat on Superior Court have sat on highly publicized cases in Boston, and everybody worries that jurors will know about the case. And even in highly publicized cases, we find very few jurors who know about the case. Is there really a meaningful concern that the jury pool is going to be poisoned by what is said in the National Law Review website and arguably picked up by other Internet sites?
If Your Honor, as Your Honors know, the exposure of juries to infection by material cast onto the Internet is a serious issue facing trial courts all over the country, and we provided articles and decisions in our appendix to show that. And it seems to me that one of the question here is, did Judge, obviously, the primary question is scope of review, did Judge Hinkle, abuse her discretion, extremely difficult test to me, by taking in context the fact that Mr. Brewer was in and out of the case, that on the same day that the local counsel said that only Mr. Garner would be moved forward, on the day that that was published, then when I find out about this, or not when but when the defendants learn of this and we oppose, then on November 2nd, as the record shows, there is a further communication from counsel responding to my objections and stating that Mr. Brewer's motion will be, they expect to move it later on to be admitted.
But, so, okay, he moves later on, and Judge Hinkle says, no, absolutely not. I mean, that's a different question.
That's a different question, but the question that Your Honor asked about the impact and the work of sub D of 3.6 is the important one. It's not, it seems to me, possible to say that the junior lawyer working on the case, Mr. Garner, under the direction of the man who has been senior to him in this case, in talking about this case, that the loose words that his senior used cannot be used to keep
Okay.
keep the junior out of the case, who will be governed by the senior.
Mr. Muldoon, would you agree that if we don't find a violation of Rule 3.6, then there has been essentially an abuse of discretion?
The test for that, it seems to me, is the one that's set out in the Deluzio case, which we cite and rely on. If the court finds that this statement was not a violation, as if Judge Hinkle had done that and had allowed the motion, I think Your Honors would say that we might not have much of a case to come up before yourselves if she had done that. The test is not, would you have done what she did, as all trial judges know. The decision is yours, and the decision is one of discretion. And the decision of discretion depends on the context. And the context here is that the junior was held by Judge Hinkle after she found that these words did violate.
If it's an error of law, I mean, if it's plainly
If it's an error of,
if the proper use of discretion
if the court
turns on it.
If the court finds that there was a manifest error of law in the construction of these words, then yes, that would meet the test. But she did not, because it's not a question of interpreting, of defining a sort of a pronged test to do it. It's the judge's discretion as to what's best for her court.
How do we know she found that?
Found.
What you're suggesting she found, that within her discretion, she doesn't make a finding, she just refers to you.
Well, she makes findings, but there's no obligation to make findings, as Your Honor knows from the Deluzio
She
case.
adopts the paper.
And she adopts our findings, and there's been no question that any of those findings that she adopts in our filings have been disputed by anybody. They form no part of the case on appeal here from the denial of the motion. I see my time is up, if it pleases the court.
This is about Deluzio. One of the points made in Deluzio is there's no showing that the plaintiff in that case is not adequately represented by local counsel. You're not relying on that, are you?
No, we're rallying.
I'm sorry?
What we're relying on is that we
I mean, is
believe
that, I guess my question, I have
Right.
no question that there's very competent local
Right.
counsel. That's not the issue. I guess my question is, in 2011, as opposed to 1984, do you think that is a valid reason on which to disallow a motion for pro hoc vice admission, that local counsel is adequate?
Until Deluzio is changed, I think it is.
Thank you.
Thank you very much, Your Honor.
SJC-10807, Metropolitan Property Casualty versus Morrison.